Good afternoon. Thank you for joining us at Toy Fair University. Next up, we have IP in the toy industry with Frank Sardone. Frank?
Good afternoon, everybody. Sorry, it's a farther walk than you realize, right? So hopefully everybody had a good lunch and having a good toy fair. Thank you for the association for having me. We have, less than now 20 minutes, but a lot of IP stuff to cover. I'll try to give you some highlights on some things as best as possible, and we'll get going. So IP, intellectual property, right? It's a general term. It covers lots of different things. You hear IP. So we're talking about 4 different things. We're talking about patents, trademarks, copyrights, and yes, trade secrets. And we'll talk about how does trade secrets play into the toy industry, but we'll talk about some of that as well, right? So these 4 things in combination constitute intellectual property, IP, right? So we take each one individually. Patents, and here are some examples. Patents, they protect inventions, right? They're systems, widgets, processes, right? They talk about the, what the item is. Trademarks, right? It's a designation of the source of the goods. Where are those coming from? You think of all the different companies that are here, whether it's the Hasbros, the Mattels, the Legos. You think of those names and you immediately understand what that product is, what the company's like, what their essence is, right? So trademarks. Copyrights, a lot of the products here have, styles, the look to them, or they have instructions inside of them. They have some artwork associated with it, but mostly copyrights, we think of games, software, music, those kinds of things, right? And then trade secrets, and I have just one example here, but trade secrets, like what is the product made of that nobody can figure out, the secret formula of that product, right? There's a lot of squishy things out there, but what are those made of? Here we have Silly Putty, if anybody remembers what that is, right? What was that made out of? And there's all kinds of things, whether it's WD-40, KFC recipes, all those things are trade secret. And now as technology evolves and AI evolves, some toys and some of the products here are integrating more of the behind-the-scenes computations and how are those things being calculated, determined, what is it doing? All that stuff that's the algorithms are things that can be kept trade secret so nobody can figure out, well, why does your item do what it does so special? Maybe we don't want to disclose that to the world, right? So something to think about. All right. So what is IP? We use this as one example that has multiple things that are associated with it. It's a square shooter game, but it's got a patent, as you can see, right? It's covered by a patent. It's also got a trademark for the square shooter, the name, and it also has some trade secrets. Well, not trade secrets here, but the copyright as far as the artwork that's associated with it. That specific artwork is copyrightable. So you have 3 things that are covered by IP for this one product that you should think about. Maybe your product has it or needs some of this kind of protection. So who are IP attorneys? I'm an IP attorney. There's IP agents, and so I'm a prosecutor. So what I do is I represent clients in front of the patent office and in front of the trademark office, and I help clients get intellectual property patent rights, trademarks, and copyrights. So I work on behalf of clients to get those in front of the government agencies, right? So we're attorneys, there's agents. I went to law school. Others, are engineers that have gotten licensed before the patent office. So they're not lawyers, but they can also do IP work as well, right? Degrees in hard sciences. So my background's in mechanical engineering, but usually we're engineers, physicists, scientists. We work with the U.S. Patent and Trademark Office, the Library of Congress, and other departments and agencies, around. Litigators, which I do not do, thankfully, but, they help, clients, hey, somebody's infringing your product, or you're infringing somebody else's product, right? So you might end up in a lawsuit, court case, to find out, all right, who's right here. So sometimes I'm the good guy, sometimes I'm the bad guy. I'm the good guy when I'm working here, I'm helping clients get those IP rights, getting those patents, securing those trademarks, getting those copyrights. That's great. I'm doing wonderful work. Everybody's happy. people are not happy when I'm hired or somebody like myself is hired, and they come to me and say, hey, Frank, I want to make this remote control, but Janice there has a patent on that remote control. How can I do this and not infringe her patent? Help me. Well, okay, so now I'm circumventing somebody else's patent, and that's work I do, and now I'm the bad guy, right? So now I'm the bad guy because somebody's got patents, and I'm trying to find a way, a path forward for my client to do arguably the same thing, but not be responsible or but not be liable. So good guy, bad guy. So maybe prosecutors as well, U.S. court system. Where do you find us? Here, right? You find me here. You find us at trade shows. You can find us at your local bar associations. You can contact the Bar Association. U.S. Patent and Trademark Office has a whole roster of all of us who are registered there. My registration number is like 47,900 something. In all of time, there's only, I think, 80,000 in all of time. So there's not a lot of us, but we're around. So there's a limited number. Local inventor meetings, you may have plugged into some local inventor meetings. You'll find sometimes I attend to talk to the community, right? What are you working on? How can we just be a resource to answer questions? Toy Association, right? Ask the Toy Association or other associations, hey, do you have any members that are patent attorneys, right? Conferences, referrals and recommendations. That's always a great one because if somebody's happy with what I did and you're talking to somebody over lunch, hey, that's always a great resource. The internet's great, but there's a lot of good information, bad information out there. Do your due diligence, vet who you're asking, who you're meeting with, because the process that we're going to engage in, or whoever you engage, it's not a 1 month thing. It's going to be multiple years ongoing. So you want to find the right fit for you, right? So patent protection in the US, for a patent, right, it's got to be new, useful, not obvious. And I only share that just as a touch point. We won't get into too much of it, but keep in mind, to get a patent in the United States for your invention, your idea, it's got to meet these 3 qualifications: new, useful, not obvious. Also, the patent is only in the name of the inventor. The inventor can assign it to a company, but it's in the name of the inventor, right? So whoever is the inventor has their name on the patent. You have to file your patent application within 1 year in the US now of a public disclosure. So you're here in a trade show, you might have something that you want to show somebody, you might show them your idea. Keep in mind that in the United States, you have 1 year from that time to file, or else you're banned from filing. In Europe and other jurisdictions around the world, it's immediately. Upon a public disclosure, it's immediate. So what's some protections against doing that? There's a few things that we can talk about. Provisional patent applications are available to file. Non-disclosure agreements are available. Confidentiality agreements are available. All things that you not making this public disclosure until you've filed something maybe with the patent office. Obstacles to patents, costs. There's a cost associated. Time, it takes time to get a patent allowed. So if something's going to be in and out of the market within 1 season, you might file a patent application and you won't hear from the patent office for more than a year. And so what's the point? So these are conversations you should have with your attorneys before you make a decision in going in these directions. Enforceability. All right, I help get the patents for people, but now there's no patent police. You don't dial 911, and hey, somebody's infringing my patent, go get them. You are your own patent police, right? You're going to have to monitor. You're going to have to go to trade shows. You're going to have to walk around, look who's doing what. Is this potentially knocking my patent off or not? So you're your own police force, right? Yes, your attorneys can help you, and I do that on behalf of some of my clients. I'll walk around and keep an eye out for different things that I'm aware of that I can bring to their attention, right? And is it worth it? So it's a lot, right? It's a lot to go through. It's a costly process. It's a time-consuming process. So here are a few examples of a toy figure, a dye agitating device, a self-propelled device, and a system and method for filling containers with fluids, right? What are all these things? Was it worth it for these people, right? The toy figure, was it worth it for them? I don't know. You tell me. Was it worth it for them? Maybe, right? Maybe, right? So there's all kind of licensing, all kinds of different things involved here, right? But maybe it was worth it, right? A dye agitating device. I don't know if anybody's old enough to remember this, but the Pop-O-Matic, right? Everybody remembers that. So the popper was the patent on this thing, right? So was it worth it? Yeah, maybe, right? Self-propelled device for interpreting, and it was a long thing. So a number of years ago, there was this company here at New York Toy Show and around, and the company's called Sphero. They had a patent to a remote control ball, right? And so here it is. Here's their product years ago. And then the company was Farrell, and they leveraged it into a licensing play to have a remote control BB-8, right? So yeah, there's a pathway, right? You don't know where, and it maybe wasn't a toy-related item, but somebody had an idea for this, and so here you go. So an assisted method for filling fluids, right? So does this look sort of, I don't know, it's hard to tell on screen there, a little bit larger here. Maybe you recognize this now, you know, a bunch of balloons, right? A bunch of balloons has their patent, but then there's Balloon Bonanza. Looks a lot the same, doesn't it? Right? So this is where you have to go police, right? So in fact, a bunch of balloons did file a patent, you know, infringement case against Balloon Bonanza, and they got some judgments for infringement and whatnot. But you can see how the process, and you know, it's a time-consuming process, and it's a difficult process, but it's doable, right? So trademarks, turning the page real quick to get through some other things. It protects the words, the symbols, the logos, and the sounds that you hear, the NBC, or in fact, Harley-Davidson got a trademark for their rumble of their engines, right? So things to think about. Do you want to kind of lock that up to be exclusively yours? Market recognition, the trademark office rights are enforced in federal court, you know, and here are some, you know, the Shell, Coca-Cola, some Big Mac, right? But so the NBC, I have that there as the chimes that you hear on NBC, right? Play-Doh, why is that there? Well, the smell. That smell that when you open up the container, that's trademarked to Play-Doh, right? And UPS is there. Why is UPS there? You know, well, colors. So the brown trucks, they're the only ones that can use brown delivery trucks, you know. So, and there's other products out there that all different colors that they lock up for that exclusive product, right? So trademarks, you know, extends. Now we're in the toy space, and there's a lot of remote control vehicles out here, ride-ons and whatever. So for an example, this is a trade dress, similar to trademarks. It's the companies like GM, they protected the look of their Hummer vehicles. So you can't just make a Hummer toy without going to GM and asking them for the rights or to use that, you know, vehicle design as part of your marketing. So you're going to need protection or requests and licensing from the GMs to be able to make a truck, a vehicle that's a Hummer look like. And now that extends into the virtual space, you know, any, you know, Grand Theft Auto, how many vehicles are in that, are either Mercedes or high-end you're going to have to get those. You can't just use them in your video games without getting licenses from those companies. Copyright, which is just real quick, we're talking about the artwork on the cards, the game boards, the video games, the look, right? All that stuff is protected by copyright, and just so that nobody else can cover that. And copyright lasts for the author's life plus another 70 years, unless you're doing a work for author. All things we can talk about offline, but just be aware that these things last. So patents are good for 20 years from when you file. Trademarks are good for as long as you continue selling that product, and the government's going to want money every so often to make sure you're still using that product and selling that product under that logo. But copyrights, there is a finality to it, but it's a long one. It's my life if I did something, plus an additional 70, 90, 120 years if you fall into different categories. So things to think about. Limits to copyright, you know, we don't need to get into too much, but you can see that there's multiple, sometimes, board games that have different looks to them, but the play pattern is the same. And the play pattern is not covered, but the artwork is covered. So I use these, and you may not be familiar with those, but people might recognize Apples to Apples as a board game. And if you've played that, and you've played, you know, Cards Against Humanity, is it really played any differently than one another? Not really. They are the same play pattern, but the artwork and all the other things are different. So they can coexist, but the play pattern might be the same. So it's not covered by copyright there. So copyright mistakes, you wait for somebody to knock you off before you file. These are all things that we could discuss. When is it right to file for copyright? Copyright exists upon that artwork being created. So as soon as you create that piece, you're good. It's attached. If you want to file a lawsuit, because somebody's knocking off, then it's recommended, and you have to. It's almost a threshold question. You have to file for that copyright registration. So we don't need to do RoboCop, Angry Birds, or ill-tempered birds. We could talk about those, right? And why does IP matter? IP adds monetary value. Premium, you pay a premium for this, and you pay a premium for that, as opposed to other products out there, Tiffany or Apple. Starting a toy company, it's expensive. You want to get your business name with the Attorney General. Social media, you want to lock up nowadays. There's accounting and marketing and innovation that's involved with patents and trademarks, and we're only at that level, the innovation. All that other stuff, starting a company is daunting sometimes, right? So just a few more examples, starting companies, just running out of time. Just want to kind of get through some branding, and you need some choke hazard regulations and all kind of testing, product testing, some challenges there. So some examples, right? The lava lamp, many of you are familiar maybe with the lava lamp, covered by lots of different things. It's covered by patent, right? It's got a patent for it, and we can talk about what is in there. There's trade dress, the shape of the bottle, is a trade dress, and there's the registration for their trade dress for the lava lamp. And then also more patent protection for the trade dress, or design patent protection for the bottle, right? It's copyright because of its artistic in nature, and there's trade secret on this because even though the patent says what's in the bottle, it doesn't give you the exact formula or how to combine the things to replicate what's here. So, when I was younger, I tried to make my own, and it didn't really work out so well. So anyway, so lava lamp, a few more examples. This guy, you might recognize this guy, he's covered by lots of different things. Patent, right? Really a patent. Yep, here he is for Optimus Prime patent. Trade dress, for sure. Copyrights. Here's a box. I actually own this item on my shelf at home, and here it is. Years later, my wife is like, why do you still have this? But that's a whole nother story. And so other examples, why it's worth it. Voltron, similar as, but all different things that cover, protections. And is it worth it? Even Funko licensing, this was worth, $20, So power of marketing. Slanket, Snuggie, anybody familiar with one or the other? In fact, Slanket was the first to market, but nobody really cared for the name. But Snuggie they loved, and so Snuggie survived, right? So first to market is powerful. So being first to market, or not, depending on the name. So other iconic, the Super Soaker, R2-D2, the Rubik's Cube, and Light Bright, right? So all different things, where you're here, you're going to see different things. Different things are covered by patents, trademarks, copyrights. Frank Sardone, sorry for the late start. Had to power through a few things, but here's my information. Please feel free. Questions, we have a minute or so, but I'll be on the side here answering questions for anybody. But yeah, please feel free.